Hi, Miss Cleese, you can speak if you want to
Okay.
test it.
Thank-
Yep, you're
thank-
good.
Okay, thank you.
Thank you. Malachi, did you already throw everything to the bench?
Yes, I did.
Okay, so I'll
Was
turn
I not
my,
supposed to?
that's fine if you want to do it that way.
Okay, I just.
Good job, Joe.
Let's see. Hey, Heather,
Yeah,
whenever Judge gets a moment, could you ask him if he could log into all these here for me, please?
sure.
Thank you. Think it's going on. Yep. Thank you. For asking.
Not only that, we're gonna have a meeting. Hey, Evelyn. I had rabbits too last night.
Cecilia?
Yes, can you hear me?
Yep. What are you here for?
Okay, Judge Oakley.
Yes. What are you here for? What case are you here on?
Okay, 23-01515.
And what party are you here on?
I am the plaintiff.
So you're for Banatoya Greenhouse?
Yes,
Okay. Are you the owner or?
yeah, one of the owners. Yes.
Okay.
Yeah, I wanted to make sure that I was in the queue waiting,
Yep.
had a
Um,
schedule.
But what I'm gonna do is I'm gonna put you back into the waiting room. I
Sure.
do have you checked in, but we still have our 8:30s that we need to handle. So I'm gonna put you back in the waiting room for a few,
Oh,
okay?
Oh, absolutely. Thank
Thank
you.
you. Lee, Mel,
Yes,
did you want to have a breakout room with Mr. Munson?
that's fine.
All right. That was quick. Are you guys ready to see the judge?
We are. We just need some time for discovery, and that's it.
All right. On the iPhone, what is your name, please?
Good morning. How are you today?
I am fine. How are you?
I'm doing great. I'm the attorney for Spring Oaks Capital versus Joshua Bell.
So you're from Michael Oldcheese, or you are Michael Oldcheese?
I'm actually Cezanne Barda from Weber and Olsey's firm.
Okay. And so how do you spell that so I can rename you?
First name is S as in Sam,
Mhm.
A, Z as in zebra, A, N as in Nancy.
All right.
Last name Barda, B as in boy, A, R, D as in dog, H, A.
All right. Hi, I know I'm going to get it wrong, but T. Wisehouse? Hello. Hi.
Hi, how are you?
I'm fine. So you're here for Howrlow, Rachel?
I am here for, yes, for Rachel Harilo, correct. And
Thank
it's
you.
Terry Weishaus.
Wisehouse. All right. All righty. We're just waiting for everybody just has one party here. Hold on real quick.
Yeah, I gotta get that.
All right, gentlemen, your appearances on Community Financial versus Neshwa.
Your Honor, Lee Meldy, PA 3783 on behalf of Community Financial.
Good morning, Grant Munson, P 71994 for the defendant.
Good morning. What's scheduled today, fellas?
This is a pretrial, Your Honor.
And where are we at? You guys playing well together?
We're asking for 60 days discovery today, but yes, we are playing well.
I don't think
All
you'll be
right,
seeing.
You're okay with 60 days, Ms.
Yes.
Munson? We looking at written discovery, guys, or do you think there's depths involved?
I think just written.
Right.
All right, you want to just schedule another pretrial?
Sounds good to
Yes.
me.
Let's just adjourn the pretrial for at least 60 days out, give you a chance for some written discovery. Anything else we can handle today?
Nothing, Your Honor.
Nothing for me.
All right, have productive days, gentlemen.
Thank you.
Thank you. You too.
Thanks.
Hi, on the phone. What is your name, please?
Joyce White.
Joyce White.
Yes.
All righty. All right, I'm going to put you back in the waiting room. I do have you checked in, waiting for the other party to appear, okay?
Okay, thank you so very much.
You're welcome. Nerone Parker.
Yes, I'm here.
Nerone, what case are you here on?
You can hear me?
I can hear you.
My case number is 24WM007418.
Okay, you're in the wrong area. Let me double check for you where you need to be. It was yesterday at 9:30. So you might want to contact the or contact the traffic criminal department.
I called you guys yesterday and all. I was in the same thing and I didn't get no answer.
Okay. Unfortunately, it was yesterday, so you'll need to contact us on the website then. Go to the website and do the contact us and let us know that you missed the hearing and double check with your address and phone number with them.
And how would I do that?
Go to the website to the contact us. 34th
Okay.
District Court website.
Okay.
All right.
Thank you.
Thank you. Hi, Melissa. What case are you here on?
Hi, I'm here sorry, I just lost my notice to appear here. Concordia versus Watts for the plaintiff.
All right.
We actually e-filed a stipulated order for conditional dismissal yesterday, so we're resolved. But the clerk told us to go ahead and appear if it wasn't entered yesterday.
All right. Jack, are you able to double check on that to see if it came in today?
Hey, could I have the case number again, please?
232886.
Okay, 1 second.
Thank you.
You got it.
You did receive the conditional dismissal?
Yes.
All right. Did you hear that, Melissa?
Yes, I did.
All right. So you're all set.
All right, thanks. I think Attorney Evan Check's probably gonna pop on at some point. If he's not already, I guess you'll let him know the same thing.
Yep. We'll let them know.
Thank you.
Thank you. Have a good day.
You too, bye.
Hi, Mr. Sackla.
Morning. Hi, how are you?
Good morning. I'm fine. Did you want to have a breakout room with Mr. Ackerman?
I can briefly, yeah.
Okay. All right, Mr. Best, you are here for Discover Bank?
Yes.
All right, we're waiting for the other party, which looks like she just got here. Did you want to have a breakout room with her?
Sure. We'll take a second.
Hi, Claudia.
Hello, how are you?
I'm fine. Your last name Kopinski?
Yes, it is.
Okay. All right, I'm going to put you in the breakout room with the attorney.
Okay.
Sorry, everybody, for the 8:30. We just have to wait till 9 o'clock for, we give everybody a half hour on the other side. So just waiting for waiting for your other side to appear.
And Heather, this is Attorney Cezanne Barda for Spring Oaks Capital. I just want to let you know that the other side, Joshua Bell, who's represented by Attorney Aubrey Tobin, I've been in contact with him numerous times, and I think we're just getting dates today. So I don't know if the court needs to wait for Mr. Tobin. Even if he doesn't show up, I'd be asking for an adjourned 60-day pretrial as well. So,
all right. Well, then whenever the judge comes out, I'll have him call your case when we get other ones. But we do have to wait just a little bit closer to 9 for him,
Nope.
I guess. Okay.
yeah,
Oh, look, it's Tobin right now.
Hello. Can you
Hi,
hear
we
me?
were just talking about you.
Oh no. I hope it was okay.
Kind of. Mr. Barta was being nice.
Okay.
When the judge comes out, we'll give you guys, have the judge talk to you about that.
About what?
Thank you.
About me being nice?
No, I was saying, that he's probably going to adjourn the pretrial 60 days to allow us just to finish our fraud through our client.
Okay.
Thank you. Sorry. Be back.
Appearances on Spring Oaks versus Bell.
Morning, Your Honor. Aubrey Tobin.
Good morning, Your Honor. Cezanne
Go ahead, I'm sorry.
No, it's okay. Cezanne Barda, P65425 on behalf of plaintiff Spring Oaks Capital.
Good morning, Your Honor. Aubrey Tobin appearing on behalf of the defendant, Mr. Bell. And
All right, pretrial scheduled today, fellas?
Yes.
Yes, Your Honor. I'm requesting 60-day just to adjourn the pretrial. Mr. Tobin has claiming fraud. I believe that it is fraud. However, my client just has to take all the fraud information and do their own investigation before coming to a conclusion.
All
To
right,
be
so we're
clear,
not talking
fraud
about
on
any debts.
somebody else's behalf, not Mr. Bell. It's a matter of stolen identity, Your Honor.
Okay, so we're not talking about debts, just some written discovery, exchange some information.
Yes, and we've been doing that already.
Okay, we'll just get you a new pretrial date, 60 days out.
Thank
At
you, Your
least
Honor.
60 days out.
Thank you, Your Honor.
All right, good luck, gentlemen.
Thank you.
Mr. Sackla, are you ready? Mr. Ackerman, are you ready?
Yes, we're ready.
We're ready.
All right. Judge, are you still out there?
I am. What case was that?
This is preferred versus progressive, the very first one on the docket.
First file. Appearances, please.
Your Honor, Freddie Sackler appearing on behalf of Preferred Medical.
Good morning, Your Honor. Nicholas Ackerman appearing on behalf of defendant Progressive, P number 85192.
All right. What do we got?
Judge, we're asking for 60 days discovery. We're going to mutually exchange some documents with each other and a motion date for motions for summary.
And the discovery will be using for either written and depositions if necessary.
Okay. Do you want me to just adjourn the pretrial, or do you just want me to put a discovery period in with the idea somebody's going to notice up a motion before we get to the end?
I think an adjournment of 60 days will probably be easiest. If we need to file a motion, we can simply file a motion and contact the court as to what date and time would work best. So
yeah, any motion we're going to file, Judge, will be post discovery, so that's fine.
Okay. All right. So I'm just going to adjourn the pretrial. I made a note for discovery. Did not limit it to written, as long as that's by stipulation.
it's fine with me. Is that fine with you, brother counsel?
I mean, I'm not doing any depths, but if you guys want to do one, I don't care.
Okay.
Thanks,
Okay.
Judge.
Would you like an order for today, Your Honor, or will we simply just get a new notice for the?
I don't need an order at all.
Okay.
I don't need an order at all. If you guys want an order, send me one.
Okay. Thank you, Your Honor.
Have a great day.
Good morning, Mr. Zettelpolsky. That's it.
Good morning, Heather. Greg is just fine. How are you?
I am fine. How are you?
Good. Should I mute myself?
If you don't mind.
Okay.
Mr. Meld, did you need something again? Or are you here on a different case now?
I have another hearing.
Oh, which one?
DNF Associates, it's Rochelle Johnston's motion.
Oh, there. So are you here for Renner?
Yes.
Renner's office? Okay. Sadie, I'm going to put you back in the waiting room. We're still finishing up the 8:30 and 8:45 cases, okay?
Sure. Okay. Thank you.
Thank you. John Eads,
Yes, I'm here.
are you here for SA Express or for Rena
Yes, I am.
Center? Okay,
Yes, I am. No, I've got to change my
I'll do it right now.
logo. S and A Express. Okay, should be all set.
Thank you.
Thanks. Are you Heather?
I am.
Nice to meet you.
Nice to meet you. Greg, did you want to do a breakout room?
Sure, absolutely.
All right.
Oh, Mr. Zlatopolsky, how are you?
Anybody here on alternative lending?
I'm here on that one.
Counsel, your appearance, please.
Good morning, Your Honor. Mimi Kalish. My P number is 52383. This is the date and time for plaintiff's motion for summary disposition. This was a consumer loan. The defendant has failed to appear or to file a written response to the motion. I know
You
the
win.
court. Thank you, Your Honor. And I do have a revised proposed order than the one that's attached to our motion because he has made a payment. If I
Okay.
can submit that to the court, I'll upload it.
Please do label it as revised. That way, when I'm going through them all, I'll just ignore the one that doesn't say revised.
I will do so. Thank you, Judge.
Thank you. Enjoy your day.
Thank you. Cheers.
How about Downriver Community?
Yes, Your Honor. This is Terry Weishaus on behalf of the plaintiff, P86739.
All right, counsel, good morning. What do you got?
I believe that there is a non-appearance. We are here today for a show cause issued after a non-appearance for a creditor's exam. We would ask that the court enter a default judgment, or however the court would normally handle a situation such as this.
Well, if this is a creditor's show cause for failure to appear at a creditor's exam, I assume there's already a judgment in place.
Correct, Your Honor.
All right, and were both defendants required to be here today?
Yes, Your Honor.
And what's your judgment amount?
The judgment amount was $7,527.87.
I'm sorry, I blanked. I was trying to write something down. Give me the total again.
It's okay. $7,527.87.
Thank you. Let's see if a $3,500 bench warrant on each defendant will get their attention.
Thank you, Your Honor.
Have a nice day, counsel.
Thank you, Your Honor. I believe I have a 9 o'clock with Ms. Hillard.
Okay. Okay, let's wait and hopefully she'll show up.
She is here. I just didn't know that she was here for that case.
You want to put the ladies in a breakout then?
Sure. Mr. Jamal, did you want a breakout room with Miss White?
Sure, we can talk briefly.
Thank you.
Okay.
Mr. Best, are you ready to see the judge?
Yes, we are.
All right.
Appearance on Discover Bank versus Kapinski, please.
Yes, good morning, Your Honor. Stuart Best of the firm of Weltman, Weinberg, and Reese on behalf of the plaintiff. And again, to be clear, Your
Morning,
Honor,
counsel.
and again for Daniel Best. So the record's cleared as Stuart Best, P40744.
Thank you. Ms. Kapinski, you can hear me okay?
Yep, I can.
Thank you. Counsel, what do you have?
Yes, good morning, Your Honor. This is our motion for summary disposition. The defendant has filed an answer. We've responded to the questions and issues. And furthermore, our motion for summary disposition does not have a response filed to it. We're requesting judgment this morning based on the motion itself, and it presented a proposed judgment of $9,753.22. This is on a Discover credit card, and that is the balance currently outstanding, including the costs and damages as set forth in the motion as a part of the proposed order.
No, I actually go back. Just get on that for this one. All right, Ms. Kapinski, did you receive a copy of the motion that was filed?
Yes, I think.
Okay, and according to counsel, there's been no response filed by you. Is that correct, or did you file a response and we've got to find it?
No, I had sent it. I'm working with a debt settlement company, so I sent all the information to them. I don't know what it is that they've sent back to you. I really don't know.
Okay, well, I've been in this business for over 30 years and I've never seen a debt settlement company file a response to a summary disposition motion. So I assume
Okay,
they
so
haven't filed one either.
Okay, I don't even know. So okay.
Okay, all right. So but you did get a copy of plaintiff's motion, so I'm going to give you a chance to respond to that motion orally today. Counsel, why don't you hit the high points of your motion?
Thank you, Your Honor. Once again, this is for a credit card debt that's outstanding. We've attached a copy of the contract as well as the outstanding balance. Furthermore, we've also attached the copies of statements on the account where charges were made against the account, and the amount set forth in our motion is the amount currently due, including all interest, costs, and fees as allowed by statute, as well as by the contract between the parties.
All right, why don't you give me that total? What does the plaintiff think is due on that contract now?
Yes, the total balance due is $9,753.22. That's damages in the amount of $9,620.43, cost the amount of $132.79.
All right, and the total was $9,753.22.
That's correct.
All right, and Ms. Kapinski, do you agree that you owe all, some, or none of that $9,753.22?
Some.
Oh, yeah. I didn't hear your answer.
I said some.
Okay, how much?
Maybe 6,000.
And what's your argument against the other $3,700?
Listen, my fiance passed away, so this is where we're at.
I'm sorry for your loss, but I don't understand how your fiance passing
Sir,
away
I'm not
changes the
listen.
amount due.
Okay, then listen. I don't really have time to go back and forth with you guys. I try to do a debt settlement company. I don't know what's going on, and this is irritating me.
You can stop talking now. You can stop talking now.
I will. Okay.
I'm sorry you don't have time for this. Counsel,
that's not what I'm
orders.
saying. I'm saying that I've already tried to settle this.
Ma'am, I'm done listening to you. The motion's been granted. I'll sign the order. You get a copy of it. You can take that to your debt settlement company.
Thank you, Your Honor. Attached to our motion is a copy of proposed order. Would the court like that submitted differently?
No, as long as it's submitted on the e-file, we'll sign it.
All right. Thank you, Your Honor.
Judge, when you're done, next up is LVNV versus White at 9 o'clock.
All right, appearance for LVNV, please.
Yes, good morning, Judge Joseph Jamal here on behalf of the plaintiff, P71254.
Thank you, Mr. Jamal. What's scheduled for today?
We have a motion for summary scheduled for today.
And it looks like Miss White did not appear today. Did you get a written response?
She is here, yes,
Oh, there
Judge.
she is. Okay, she's on the phone. She's on the
Yes.
phone. I'm looking for a face and she's on the phone. All right. Miss White, can you hear me?
Yes,
All right. Did you get a copy of that motion filed by the funding company?
I had, only thing I got was the notice for the peer. What other thing that you mean did I get?
The plaintiffs filed a motion for summary disposition. You should have received a copy of that before you got a notice for today's date.
Oh, the package they sent me of all the invoices of the bills. I received that. Yes.
Probably. There probably was a document in that packet
Yes.
that's labeled.
Yes.
Okay. Okay. And I don't see anything in the court record, so I'm assuming you did not file a written response to that. Is that correct?
Correct.
Okay. Counsel, why don't you hit the high points and I'll give the lady a chance to respond orally.
Yeah, Judge, we did have a chance to discuss the matter before as well. I know defendant is working with the debt settlement company. We did have this previously adjourned, this motion. So I did mention to her that we may need to proceed today. With that being said, we have filed the motion based on MCR 2.116C10 primarily. We've included detailed account statements as well as any assignment related to the account. Furthermore, we do not have a response to that motion, so we would be seeking a judgment.
Okay. And what's the total amount according to your records?
$494.20 plus costs.
And what are your costs?
Costs, we have $35 filing fee, and I'm showing a service fee of $59.93.
You got a total or you want me to do the math?
I can do the total here. Give me just 1 minute.
Go
Your
ahead.
Honor. $589.13.
Thank you. Ms. White, do you agree that you owe that $589.13?
That's the total with what I owed, the filing and the, what else was it?
The total, this would be $589.13. That would include the court filing fee,
$490.
the court service fee, and the balance on your debt.
Yeah, but that's what it come to. I guess that's what I gotta pay.
Okay.
Yeah.
All right. So I'm assuming then you have no defense to the plaintiff's motion.
I would have to, like I said, I'm dealing with the debt solution. So this will be a total that presented to them on my behalf that I have to pay.
Okay. I'll take that as a yes, no defense.
Yeah.
All right. So
okay.
I will grant plaintiff's motion. You'll get an order. I would suggest that you take that order to or share that order with your debt settlement folks as soon as you can. Counsel, did you already submit an order?
We have not, Your Honor. Do you want me to submit one on the 7-day rule?
Yeah, that'd be fine.
Okay, we will do that then.
Good luck, ma'am.
Thank you all.
Thank you. Thank you.
Heather, how about the first 8:45? I see it's 9:15 now.
At 8:45, let me bring in Miss Celia. She's the owner of Toy Greenhouse. Keith
Okay.
Wiley did not appear.
Okay.
She's on.
All right, Banatoy, you got a camera you can activate? Benoti Greenhouses, you got a camera? You're muted.
Okay. I just unmuted. Start video.
Okay, what's your name?
Cecilia Banity Brandmeyer.
Okay. And Ms. Grandmeyer, is the greenhouse incorporated or an LLC?
Incorporated, a C Corp.
Okay, are you an attorney?
No.
Get one. You can't represent the corporation in a court of law. This is a court of law. I will adjourn today's hearing to give you a chance to do that if you'd like.
Okay, even though it's a civil court, I
This
cannot
is small
represent.
claims? Oh, okay. That's all right. Yeah, we can go forward if it's small claims. It's unusual for me to have a small claims hearing on today's docket. So what's scheduled today? Ma'am, do you know what's scheduled for today?
Yes, the case number.
No, what's scheduled today? What was scheduled for today? What was supposed to happen today?
I got a notice in the mail.
Ma'am, I understand why you're here. I understand you get a notice, but what business do you have in front of the court today? This is your case, ma'am.
Well, the notice was for me to attend the Zoom meeting with Keith Wiley.
For what purpose?
For the purpose of him not paying me, that I had filed a seizure of property because I went through since September 23rd of last year.
Okay. Okay.
All the
So
documentation.
you filed a seizure order.
I'm sorry?
You filed a seizure order,
Yes.
right? And what happened with that?
Okay, and then I got the notice to appear
Okay.
for the
All right,
Zoom
Heather,
meeting.
put the lady back. Ma'am, I'll get to you when I get time to figure out what's going on, because you obviously don't have a clue what's going on with your own file. So
Okay.
be patient, and I'll try to help you when I get some of these other folks out of the way.
Okay.
I put her in the waiting room.
Yeah, and call downstairs and try to get somebody to figure out what's going on with this and let me know.
All right. Let me see. Oh, that's at 9:30.
How about Concordia? Oh, Concordia was a stip. I think I signed a stip on Concordia today.
Yep, those. So 8:45 is done, except we'll recall
Yep.
Miss Celia. At 9
Yep.
o'clock, we have Parkside versus Hillard,
Yep.
and they're on.
Appearances for Parkside.
Your Honor, this is Terry Weishaus, P number 86739 on behalf of plaintiff.
All right, and Miss Hillard, you can hear me okay?
Yes, good morning, Your Honor.
Good morning. All right, Ms. Weishaus, was this a default judgment?
Yes, there have been two default judgments from 2016 and 2022 in this case.
All right, so from that, I'm assuming the 2016 was set aside and then there was no answer filed again?
And there's been several motions on behalf of the defendant. I believe that that would be somewhat of how this had occurred. There was there have been claims that there's been identity theft to the original complaint that was, there was personal service done in June of 2016. And the original default was issued on August 23rd of 2016.
Right, and then that was set aside, I assume?
I assume as well that that was how it translated. There was a motion to set aside in September of 2021, and the new default judgment after another series of motions was issued on May 19th of 2022. Okay,
And the second default judgment was entered because Ms. Hillard failed to respond or failed to show up for a hearing. What happened? What was the cause of the second default? Do you know what?
Yes, it was.
Heather, hold on, counsel. Heather.
Yes, Judge.
All right, never mind. I don't know what happened, but my Zoom page just disappeared. All right, counsel, try it again. Why was the second default entered, if you know?
Yes, I believe that the defendant had claimed that on May 10th, she had shown up to a court appearance and it had been rescheduled to the 17th of May in 2022. And at that time, it was not, she did not appear to the rescheduled hearing. And so due to that, the default was entered on May 19th of 2022.
Okay. And Ms. Hillard, when I look at a motion to set aside a default judgment, there are two questions that have to be addressed. The first question is, do you have a good reason why you didn't do whatever led to the default? And in this case, it sounds like show up for a court hearing. The second question that I look at is, what is your defense to the underlying claim? Do you understand those questions?
I believe so, Your Honor, yes.
Okay. So go ahead and answer those questions in whatever order you'd like to.
So to the underlying claim, Your Honor, I am a victim of identity theft, which is why I didn't know about the suit for so long until I was actually garnished. I have a police report. I was not served, even to the document that they sent me showing that I was served. It shows a different address from where I stayed, a different signature. Even on my license, you can see the signature doesn't match, the address does not match. Even the description of me saying they served someone that's 110 pounds. I haven't been that weight since maybe I was 10 years old. So I'm not sure who they served, who took out the loan. I am a victim of identity theft. I never applied for, used, benefited from the loan or vehicle whatsoever. And I wasn't served. To address your second question, when I did present those facts the first time, you were gracious enough to set aside the motion. I did leave the country to help care for a very sick family friend who has passed since then. In that time being, I was under the assumption that, well, not the assumption, I was told by the court that the new motion to present our defenses was for May 10th when I called via phone. And because I was in Thailand, I didn't have, an American number. It would have cost too much. So I didn't have, I was talking with my mom. I did have her to call the court for me on that day to verify that I had court that day. She translated a message to me that they said I didn't have anything for that day. So because my address was, I had it forwarded to her house, I assumed that I would get an updated mailing, from the court saying when court would be, and I did never receive that. So to my knowledge, it just hadn't happened yet. I'm not a lawyer, Your Honor. I do appreciate what you guys all do here, lawyers and judges alike, but I don't understand the legal process all that much. And so I had been waiting to hear something back, and I just got back in the country on, at the end of this year. And so when I was able to resume and see, what happened, then that's what led to this, but it wasn't because, of just negligence. And so that's my response to both.
Let me make sure if I understand this or not. So
sure.
You had a hearing, you knew about a hearing that was scheduled for May 10th.
Correct.
All right. So you're out of the country and having communication issues. So you had your mother check to see if it was still on for May 10th.
Correct.
Okay. When did you do that?
When did I mean, she told me that it was on May 10th when she called into the court, and she said they didn't have anything with that case number for that day.
All right. So I'm assuming on May 10th, you were still in Thailand.
Correct.
So if your mother would have confirmed that you did in fact have a court date for May 10th, what were you going to do with it?
Well, I was assuming it would have been on Zoom.
Okay.
Yeah, I had internet access.
Right.
I didn't have an American number. I didn't have the phone, so that's why I had her to phone in for me. But I did have internet access.
Okay. So on May 10th, you found out that the date had been adjourned to May 22nd?
No, I didn't. She told I was just going by the message. She told me that they said there was nothing on the docket for that court case for that day. So to me, it just, no one had got around to rescheduling. So I didn't know of an upcoming date.
All right. Counsel, at this point, I'm going to pass on this file. As you know, we're running on base, which is absolutely useless to me on the bench. So what I'm going to do, I'm going to pass on this file until I can look at the court register of action to see what was going on back in May. I'll be back with you as soon as I've had a chance to do that.
Thank you, Your Honor.
Heather, you got anything else that's ready to talk about now?
Yep. VSU versus SA Express.
All right, Mr. Zlatopolsky, good morning.
Good morning, Your Honor. Greg Zlatopolsky for the plaintiff.
Good morning, Judge. May it please the court, John Eads for the defendant.
Good
Your
morning,
Honor,
Mr. Eads.
Nice to see you, Judge.
What do we got, guys?
Your Honor, it's an interesting case. The liability is not disputed. The dispute is the amount of damages. I spoke with brother counsel, and we have an understanding what we might do with this case. Namely, my client will take the trailer, which is the subject matter of litigation, to a licensed dealer in Chicago to get it fixed, and his client will consider paying for it. There is no promises, but it sounds like it's the best way to go.
What do you want us to do? You want us to just adjourn things, or?
Yes, Your Honor. For 60 days, it should be sufficient.
How much time do we need, guys?
John?
60 days is fine, Judge. We appreciate the courtesy.
Yeah, fellas, I'll throw this option out there too, and this might be right for this. Liability is not an issue; it's just a question of damages. Judge Green and I have been kicking files back and forth for like an informal mediation process. After you get the trailer to the repair shop, if that doesn't resolve it, instead of coming back to see me, maybe what we need to do is just put you in front of Judge Green and see if she can't help your clients arrive at a party or a number that they're both unhappy with.
That sounds like a great idea, Judge.
Sounds like a great idea, Your Honor.
What was scheduled for today?
Pretrial.
So let's just adjourn the pretrial for at least 60 days. Sounds like you guys are playing well together. So let's adjourn it for at least 60 days, and then you contact us and let us know what you want to do. You want to come back to see me for a pretrial, or you want to go right to Judge Green for an informal mediation?
That sounds great, Judge. We appreciate your help.
Make sense? All right,
yes.
That might be the best way to get this resolved without a lot of legal fees. Okay, that's what we'll do.
Thank you, Your Honor.
Thank you, Judge.
Bye, John.
Have a good
I'll talk
week.
to you. Thanks.
You as well.
Mr. George, did you want to speak to your client?
Yes, please.
Okay, I'll bring him in just a minute.
Thank you.
Judge, next we have both parties for DNF versus Johnson.
Yep, 9:15.
Yep.
All right, appearances.
Good morning again, Your Honor. Lee Meldy, PA 3783 on behalf of the plaintiff DNF Associates.
And Rochelle Johnson.
Yes, I'm here.
All right, thank you. Counsel, what do we have today?
This is defendant's motion to dismiss, Your Honor. If I might interject here quick, I'm hearing some background noise from someone right now.
That might have been me moving my headset.
Okay, I'm not catching too much.
I can deal with it. It's fine.
Okay, now I think you got it. Ma'am, you filed a motion?
Yes, I did.
All right. Let's see if we can find it. Yeah. And counsel, there's a response from plaintiff?
Yes, we did file a response, and we served a copy of that response on the defendant, Your Honor.
Thank you. Did you see the response, ma'am?
Yes, I did.
Okay. All right.
Your Honor, may I address a preliminary matter?
Sure.
Thank you, Your Honor. I wanted to inquire about my motion to strike and reply declaration. It was submitted to your court last Thursday, April 11th. Have you seen that?
No. Is that different than the motion that we're arguing today?
Yes, I submitted.
Okay. Well, if you file a motion and it's not scheduled for discussion, that means the other side has not had a chance to review and respond. Would you agree?
Well, they responded to my motion to dismiss, and so I submitted a motion to strike and reply declaration in response to that.
We haven't received a copy of the motion to strike, and today is scheduled for a motion to dismiss.
Okay, let me
that
ask you
is
this, ma'am. What are you trying to strike?
okay. First of all, are you going to swear us in?
Not yet.
Okay.
You're not
Well,
testifying, ma'am. You're arguing. I don't have to swear you
okay.
in for argument.
Okay. Well, the attorney is not telling the truth about the motion to strike.
Okay, ma'am, ma'am, let's not make this any more difficult than it has to be.
Okay,
You
sir.
filed a motion to strike last week. What was that attempting to strike?
It was in response to their reply to my motion to
Ma'am,
dismiss and
answer my question. Answer my
It wasn't-
question. When someone filed a motion to strike, it's to strike something specific, like strike an answer. So what were you trying to strike last week?
Their reply.
Their response to your motion to dismiss?
That is correct. And Mr. Meldy said that they did not receive my paperwork, and that's not true. I received confirmation that that was signed for Friday morning by Attorney Renner.
Okay, well, that's not the attorney that's on Zoom with us, is it? Sorry, counsel?
I apologize, Your Honor. I can confirm I have not received a copy of that motion to strike.
Okay, and Ms. Johnson, who signed for that?
Attorney Renner.
Revner?
It was signed for around 9 o'clock in the morning on Friday, April 12th by Attorney Renner. And I have
All right,
proof of it.
ma'am, I'm having trouble understanding you. I want to make sure I'm hearing the name correctly. Is it Attorney Renner, R-E-N-N-E-R?
Yes.
Okay, counsel, is there a Renner in your office?
That is the owner of the company, Your Honor.
Okay. All right, so is it possible somebody received it Friday and they just didn't get it to you by now?
I mean, we keep detailed records of everything. I'm not showing, I'm looking at this case file specifically, and I don't see any history notes related to receipt of any mail. There's no document attached. And
okay.
You know,
Ms. Johnson, do you have the ability to send that? Ma'am, do you have the ability to send that motion to strike to counsel electronically?
I have a link to that. Can I provide you guys the link or?
Okay, I don't know what a link to what you mean. It's in the cloud somewhere? I don't understand what you mean, a link.
Yes, I have it. I saved it to a Proton Drive link. I can provide the Proton Drive link.
Counsel, do you have any idea what she's talking about? Because I don't, because I'm not.
I have no idea. I would prefer if she does send it electronically. It's sent by email. Otherwise, if she can fax it, I can get the fax number.
Can you
Okay,
email or
that's
fax
fine.
that, ma'am?
Yes, I can.
All right. Counsel, you want to chat the email? You want to put it out on the World Wide Web?
I will chat that, Your Honor.
All right, Ms. Johnson, counsel's going to chat you an email. I want you to email him whatever documents you want us to review today and discuss. I want counsel to have a chance to look at those documents. Understood?
Okay.
All right,
Yes.
so I'm going to pass on the file until you do that. I'm going to move forward with my docket, and then we'll come back and readdress this. Hopefully, Mr. Meld has had a chance to look at your document.
Thank you, Your Honor.
Okay.
All right. Heather, what else you got?
Mr. George, are you ready for CG Stevens?
Could you just throw me in with her one more time, and then we'll be out in like 2 minutes.
All right.
Thank you.
No, Judge, I gotta call more people in, but
okay.
I don't have anybody from Old Cheese's office or Palin's office on Capital One versus Innocent.
Okay.
I have asked attorneys in the breakout room in the waiting room if they're for her, but nobody is.
Yeah, they've probably settled that, and we just don't have the documents yet.
Well, because Miss Palin is also on a 915 case. You know, let me bring Miss Harms in and see if she knows about Miss Palin. Hi, Miss Harms.
Hello.
Hi, have you been in contact
morning.
with Jennifer Palin's office?
You know, I just texted her while sitting here. I saw your chat, and she's pretty responsive to me. I texted her cell phone, and no, I've not heard from her. So, but I wouldn't want to default her. I'd be willing to hold the PT without her.
I'm not going to hold a pretrial with one attorney.
Okay. We could adjourn. Like I said, I'm not going to default. I'm not going to ask for a default.
Okay. Yeah. How far out did you want to go, Ms. Harms?
Let's see if we could get like a 30 days. So let's see.
Yep, in 30 days, I have May 21st.
Double check. Yeah, I'm open for that. Yes.
All right, then we'll put that in for May 21st.
9:15.
Yep, that's fine.
Okay. All right. I'll let her know too. Thank you.
All right, thank you.
Mhm.
Ms. Johnson, you received that email?
Yes, I did.
Okay, thank you. Hi, Kalisha, on the Kalisha iPhone, what are you here for, please? Oh, I'm sorry, I just muted you. I was asking you to unmute. What are you here for? Unmute yourself.
Okay, can you hear me now?
Yep.
Okay, I'm here for an eviction.
But is it under your name or do you have a
My
case
name-
number?
Brittany Gary Robertson. Last name Gary Robertson. It's
Oh,
hyphenated.
I found you. Okay, yes. All right, let me bring Mr. Rourke in.
Okay.
Thank you.
Mm-hmm.
Hi, Mr. Rourke.
Morning.
Good morning. Did you want to speak with Miss Gary Roberson?
Yeah, let me speak with Brittany on a
All
breakout
right.
room.
Sure. Switch you guys over. Mr. George, are you ready?
All set.
All right, let me bring Mr. Stephen or
Ms.
CJ
Stevens.
up. Yep, Miss Stevens out. And while I'm waiting on the judge, I'm going to bring in more people and ask what they're here for. Hi, on the Galaxy. What's your name, please?
Gary Gordo.
All right, we are waiting for Mr. Pallett's office.
All right.
I'm gonna put you in the waiting room waiting for your hearing time. Hi, Alejandro.
Yep. Yes.
I'm just waiting for the attorney to appear.
Okay.
All right, I'm gonna put you back in the waiting room waiting for him to appear, okay?
Gotcha.
Hi, Albert Kim.
Yes.
You're here for Ronald Rich.
Correct.
Okay. All right, we're just waiting for somebody from the other side to appear.
Sounds good. Thank you.
You're welcome. Hi, Mr. Jolly.
Yes, finally got this thing
Yes.
to work.
That's why I kicked you out. I was hoping that that would help you, and it did. So,
Yeah.
we are waiting for the other side to appear.
Okay.
Your hearing is at 10 o'clock. So I am, now that you were able to sign on, I'm going to put you back in the waiting room because we do have more cases ahead of you at
Understood.
earlier times. Okay. Thank you.
Okay, thank no problem.
If anybody tries to talk to me, I'm stepping away for 1 minute. I will be right back. All right, I am back. Sorry about that.
Hello, how are you?
I'm fine.
Heather,
Yes.
it's Ron Brewer.
Yes.
I think
Hello.
Brittany and I have a consent that we can put on the record.
All right. When the judge gets back, I will call your case.
Very good. Thank you very much.
Thank you. Yep.
Thank you.
Yep. Hi, Mark.
Hey, Heather, how are you today?
I am fine. You just have the one case, correct?
That is it.
All right. He's here. I'm going to throw you guys in a breakout room.
Great, thank you.
You're welcome. Hi, Sean.
Yes.
You're here for Stillman's office?
Yes.
Okay. Ian?
Hello.
Hello. One of yours has appeared now. Let me see.
Elzer and Gordeau, I believe
Yeah,
it's.
Gary Gordeau is here. Rochelle, did you send that to the attorney?
Yes, I did.
Okay, he's not finding it in the emails.
Okay. I put my name in the subject line.
Does that help, Lee?
Yeah, and it might say that it's from Tranquility. That's my nickname.
I've checked every email. Non-spam. It's not in my inbox.
It's saying that it's from Tranquility. I sent it to the address that was given. Do you want me to give you? Hold on, yep, I sent it to that address. Should I resend it again?
Should try. Oh, just came through.
Okay, great.
But that's just a copy of the certified mail.
But I also put the link in there to the file that was sent to your office. You see the link? Oh, you know what?
Don't really
Okay,
plan on
maybe I
clicking
didn't
on
give you
random
the
link.
link. Oh, wait. Okay, I'm sorry, you can't click on the link?
Well, I would prefer not to click on
Okay.
a link that I don't know. I would prefer an actual document.
I'm gonna put you two back in a breakout room because the judge is coming
Okay.
out.
Thank you.
No problem.
Appearances for Shilpa LLC versus Gary Robertson.
Morning, Your Honor. Ron Ruark for Shilpa.
And Miss Gary Robertson, you can hear me?
Yes, good morning. How are you?
Wonderful. Counsel, what do we have today?
I think we have a consent, Your Honor. I'll put the terms on the record. The rent to
Go ahead.
Ready?
Yep.
The rent to retain possession is $11,850. $190 in court costs. Total judgment of possession only $12,040. $12,040. We're going to give Brittany until May the 7th to pay. And we're hoping that this gives her sufficient time to get her funding from
Can't hear
DHS.
anything.
All right, ma'am, did you explain the 3-day rule, Mr. Rourke?
Your Honor, I have not, so please do.
Okay. Okay. Ma'am, those terms that Mr. Rourke just put on the record, is that what you've agreed to?
Yes, I didn't hear him. I didn't hear nothing he said, but me and him talked. So if that's what he said, then yes.
Brittany, the total judgment
Bottom line was
only.
the total number is $12,040.
Uh-huh.
You've got until May, what was the date, Mr. Rourke? May 17th?
May 7.
May 7. You've got until May 7.
Yes,
You
sir.
agree to those terms?
Yes,
Okay,
sir.
so that means either you come up with that $12,000 on or before May 7, or you move on or before May 7.
Yes, sir.
Okay, and you're agreeing to that today. Is it all right if Mr. Rourke signed your name to this paperwork?
Yes.
And understand you've got 3 days to change your mind, just like if we were selling you a vacuum door to door.
Okay, I agree.
Understood?
Yes, sir.
All right. And at some point in this process, did you watch a 20-minute video that explains your rights as a landlord, or excuse me, as a tenant?
I watched the very first video when I first came to court. Yes, yes,
Yeah.
I did.
Okay. All right. Do you have any questions about the process, ma'am?
When can I pick up that paper so I can take it to DHS so I can get some help with assistance?
We should have that order signed today or tomorrow. So certainly, what's today? Wednesday.
Wednesday.
Tuesday. Today's Tuesday. So certainly by Thursday we'll have it.
And Your Honor, I'll submit it immediately.
And you can always call, I'm sorry, Mr. Rourke. Ma'am, you can always call the court and see if it's ready for you.
Okay.
Mr. Rourke?
I'll e-file it immediately, Your Honor.
Okay. So Mr. Rourke will probably have it in my file box online before I'm ready to get to it. So we should have it for you today or tomorrow.
Thank you so much.
All right. Any questions, ma'am?
No, sir.
Good luck to you.
Thanks,
Thank
Your
you.
Honor. Good luck, Brittany.
Thank you.
Thank you. How about Musful versus Stevens? Appearances, gentlemen.
Good morning, Your Honor. Attorney Adam Mortada, P number P83833 on behalf of the plaintiff.
Good morning, George of Lakeshore Legal Aid on behalf of defendant C.J. Stevens, who's present on Zoom.
Thank you, gentlemen. What do we got?
Your Honor, we did have a chance to speak. We've agreed to resolve possession by way of an interim order, which I will prepare and forward to Mr. Mortada. That'll just be the standard 10 days. And then we've agreed to sever the money judgment portion, and we are asking that the court adjourn that portion out to a date in early May so that we can engage in some informal discovery and explore settlement.
Sure. Heather, you got a date in early May?
Is this for
You
landlord
want to
tenant?
just call this a hearing on damages, or what do you want to call that?
That would be fine, Your Honor.
Heather, date?
Do we want your civil date, which is May 21st? Or
That should be all right.
Okay.
So fellas, put all this in an order. The fact that you're separating possession, that we're going to meet on the certain date in May to talk about damages, put all that in one order if you would.
Yes, Your Honor.
Yes, Your Honor.
And I'm sorry, that was the 21st?
That it, Heather?
Correct, yes.
At
May
what time?
21.
You both of okay.
In the morning.
Yep.
Okay.
Okay.
And if we're actually going to have a damage on hearings or a hearing on damages, I want it live. If you're going to stipulate to it all before then I'm okay with you just sending something in. But if we're gonna do damages, I'm gonna want testimony. I'm gonna want to see things in person.
Understandable, Your Honor.
All
That
right,
being the
anything else
case,
we
Your
can do today, fellas?
That being the case, Your Honor, I wonder if we might have any time available in the afternoon. It would make my drive from Grand Rapids a lot easier.
Heather?
We do, yep, we do that day, Judge. At we can do
Okay.
1:30.
That
How's
would be
that,
much
Mr.
better
George?
for me if Mr. Mortada is available then.
Yeah, I can make it work.
1:30, perfect. Thank you so much.
Great. Love it when you play well together, fellas.
Thank you, Your Honor.
Thank you.
All right. Thank you both. Heather, we got anything else ready, or can I go back to Miss Banathy?
No, Country Meadows versus Gordeau.
9:45. Appearance?
Your Honor, for the record, Attorney Ian Morton, appellate on behalf of Country Meadows.
Thank you. And looks like we've got at least one Gordeau.
Yeah.
Gary, do you have a camera? If you do, can you activate it?
Yeah, I see you.
Well, I know you can see me, but that doesn't have anything to do with what I said.
Oh, start video. How about now?
If you don't have there you go. All right, there you go. You're good.
Okay.
All right, Mr. Morton, what do we have today?
The parties did agree to enter into proposed consent judgment agreement with Mr. Gordeau. The other two parties that are not present but are aware. Rents retained $3,000, $3,007.01. Court cost of $307.42 for a total of $33,1443. We extended the normal statutory time period to the very end of the month at 4:30. I did advise him of his rights, specifically the fact it's not final for 3 business days. Second, the 10-day appeal, and he gave me permission to sign his name to the proposed consent judgment. I'm not sure if I went over this with him, but the idea would be other parties would be defaulted, but all the same terms, all the same amounts, no changes whatsoever.
Right. Mr. Gordeau, first of all, am I saying that name correctly?
Yes.
Thank you. Those terms that Mr. Morton just told me, is that what you've agreed to today?
Yes.
All right, you understand you've got 3 days to change your mind?
Yes, sir.
Yep. And you understand there'll be a default judgment with those same terms as to Tammy and Deborah.
Right.
And any questions?
No, sir.
Okay, we'll make it happen. I'm assuming you're going to send that in by e-file, counsel?
Absolutely, Your Honor. I'll be submitting that once I'm done. Once we eventually, call my other case. So.
Got it. Okay, Mr. Gordeau, we'll get that probably be signed today or tomorrow.
Okay, thank you, sir.
Good luck to you, sir.
All right, thanks. Am I done?
You are, sir. Enjoy your day.
Okay,
Mr.
bye-bye.
Morton, is that next one Holiday West versus Peltzer?
That is correct, Your Honor.
All right, and do we have a defendant?
No, not yet.
No, not that I'm aware of.
All right. All right, so let's wait a few minutes, see if we get one, Mr. Morton.
Understood.
Heather, anything else
Yep.
ready?
Parks at Concord versus Price.
Appearance on Parks?
Good afternoon. Good morning, Your Honor. Mark Swessinger, standing in for the attorney of record on behalf of plaintiff.
Thank you. Mr. Price, you there?
Yeah, I'm here. I had to fix my
Thank
thing.
you.
I'm here.
All right, counsel, what do you got?
Your Honor, I've talked to Mr. Price. We have worked out the terms of a consent judgment. The terms are as follows. This is possession and money judgment, Your Honor. Current rent to retain, $5,625.41. Court cost $247.79. Total to retain and the total for the money judgment, $5,873.20. I've moved the writ date out to 4/30/2024. I did explain MCR 4.201J to Mr. Price and did receive his concurrence to sign his name to this proposed consent judgment.
All right, and Mr. Price, those terms,
Yes.
is that what you've agreed to today?
Yes, Your Honor.
You understand you got 3 days to change your mind?
Yes, I do.
Any questions?
None.
All right, I'll get it signed as soon as I can get to it.
All right.
Good luck, sir.
Thank you.
Thanks, Judge. Good luck, Mr. Price.
Thank you.
You
have a
got
good
it. You too, sir. Thank you.
Judge, at 9:30, we have Credit Acceptance versus Weston.
Yep. Appearance?
Good morning, Your Honor. Lisa Ledger, P80871, standing in for attorney of record Richard Rusin for the plaintiff.
Thank you. Mr. Weston, you can hear me okay?
Yes, sir.
Thank you. And Mr. Weston is, I think today's scheduled because you've objected to a garnishment?
Yes, sir.
Okay. And I don't know how fast you can find that. Let me get my hands on that document you filed, sir.
All right, Your Honor, I am happy to report that we have come to an agreement outside of the garnishment, if Your Honor would be interested.
Perfect.
Okay,
Tell
Your
me about
Honor.
it.
So they have already taken 2 payments out, but my client is willing to suspend the garnishment and accept payments of $500 per month as an installment payment plan. And
Right.
provided those 2 payments get to my client, that I think one came out on the 5th and another one's coming out this week, we would allow the payments to start on the 25th of May. As we know, he's already had the substantial deductions from his paycheck this month. So we'll let him take the month to get his finances together, and we can do 500 months starting May 25th. And of course, if those payments don't come through, we would file a motion for to set aside the payment plan and ask the garnishee to take that garnishment out of suspension and reissue.
All right. So I'm just going to make a note that an agreement has been reached and an order will follow.
Absolutely, Your Honor.
All right, Mr. Weston, counsel's going to send me an order and I'll get a signature on it. Understood?
Yes, sir.
Any questions?
No, sir.
All right. Have a nice day.
Thank you so much, Your Honor. Have a wonderful day.
Thank you.
You're
Bye-bye,
welcome,
everyone.
sir. Heather?
That's it. If you want to recall the DNF versus Johnson, and then we can go to Miss Hillard's case. At the 915 DNF versus Johnson.
Yeah, what were we doing with that one?
You wanted to reschedule. Miss
Oh, that's all
Johnson.
the paperwork. Yeah, that's all the paperwork. Yep, thank you. Yep. DNF versus Johnson, please.
Lee Meldy, Your Honor, P83783 on behalf of the plaintiff, DNF Associates.
All right, counsel, I've got my hands on what was filed Thursday, and it's 32 pages long. So I don't know if you received the email or not, but I'm not going to make you digest that today.
Yeah, I reviewed a couple of pages of it. I mean, my document's 40 pages long, and it's not addressed to be.
Here's what we're going to do. Here's what we're going to do. Heather, what's the date?
Do you want it just on your next civil, May 21st, or you wanted it soon? Okay, May 21st.
All right. You two get to come see our new courthouse. I'll deal with all this on May 21st. I can give you a morning time or an afternoon time.
I would prefer afternoon, Your Honor, since I'll be coming from Grand Rapids.
You should probably talk to Mr. George. Maybe one of you guys could save the drive and send the other one down for you. How about 2 o'clock?
That's fine, Your Honor.
Ms. Johnson, 2 o'clock on the 21st?
Yes, Your Honor.
All right. We'll see you both then.
Thank you.
You're welcome, ma'am. Heather, can I go back to Miss Banatty?
Parkside versus Hillard. That one.
What were we doing with that one?
You were going to look over the paperwork.
Oh, that's the ROA I want to look at.
Yeah.
Let me deal with Miss Banatty. We've got too much stuff we've been shuffling around.
What's
Let me deal with
Banatty?
Miss Banatty while.
What case is that?
First one at 8:45. Greenhouse versus Wiley.
Okay, let me bring her in. Thank you. She's in, Judge.
All right, ma'am. First of all, pronounce your name for me. I always pronounce it Benotti.
Vanity, like vanity.
Vanity. All right. Vanity. All right. Well, that delay gave me a chance to figure out why you're here today. And basically it's because we're confused. You filed your original affidavit and said that there was $6,802 and change due. And then we've got a judgment. And hold on a minute. I'm going to give you a date on that. There was a default judgment entered on February 15, 24 for $6,645. And then most recently, we've got a request in order to seize property that lists the judgment amount at $6,800 and then showed interest of $1,165 and costs of $209. So none of these numbers are making sense to me. So I've got to figure out where all these different numbers are coming from.
Okay, when I had filed the seizure of property, Judge Green had said you cannot collect interest from the money judgment from the time when they owed you the money. It had to be from the time you had originally filed. So I had to go back and recalculate. That's why the numbers have changed.
There's pre-judgment and there's post-judgment. Okay, so anything pre-judgment would have been included or should have been included in the default judgment. You follow me?
Oh, okay. When you say the pre-judgment was what I had originally added the interest from the time when he owed me the money, not from the time I originally filed. Is that correct?
Correct. That would be part of the claim you're making in the small claims case is, for example, and I haven't looked at all your paperwork, but for example, if I go get my car repaired at the dealership, there's a little segment on the invoice that says, you know, payment is due within 10 days. If not, it's going to be 1% a month every month or whatever it is. Okay. So if they sue me a year later, they're going to sue me for the $1,200 repair bill plus the 12 months of interest. You follow me?
Right.
That's hashed out in the lawsuit. They get a judgment against me for 14 grand, for example.
Right.
And now the interest they're entitled to is usually a different amount than they might have been entitled to before the judgment. Post-judgment interest is kind of a scale that's based on treasury bills, and it changes, I think, I don't remember now, I think every 6 months. So that's like a moving target.
Right.
Usually the pre-judgment interest is set by contract between the parties. So where we're at today is you've got a judgment for $6,645. Now you're trying to collect on that judgment with seizure of property, correct?
Correct.
So I've got to get to a point where I can justify the number on that request in order to seize property. So we start with the $6,645.
Okay.
That was, I already forgot the date. That was dated 2/5, February 5.
2/5. Okay.
Because I can't tell you what the post-judgment interest is because I don't do the calculation.
Okay.
So since February 5, you're entitled to post-judgment interest on your $6,645. So I'll leave it to you to do your research, figure out what that post-judgment interest is. Let's talk about costs. You've listed $209.90 in cost since the judgment. What are those fees that add up to $209?
Okay, that is for the court cost.
What court cost, ma'am?
Okay, my filings and also
that's all supposed to be part of your judgment, ma'am.
I'm sorry?
Your original filing fee, your original court cost, those are all supposed to be part of your judgment award. The costs that you're entitled to now are post-judgment costs. In other words, costs you've incurred since February 5th, 2024.
Oh, okay. Okay.
So we've got the judgment amount of $6,645. We've got the interest rate, and when you submit this, I want you to show how you calculate it. What rate, how many days, so on and so forth. Then you've got your post-judgment costs. For example, whatever it costs you to file this request in order to seize property, I think it's $20 or $25. You're entitled to that. Okay? Then the next line on the form is a deduction for whatever payments Mr. Wiley has made. Then that gets you to a bottom line And that's what the court officer is going to be authorized to go out and collect by seizing property. Do you understand that?
Okay. Okay. Yeah,
Okay,
because
now, go ahead.
okay, because I just wanted to be clear that the original on 9/23 that I had submitted, the claim, okay, that had included that interest prior, and then Judge Green wanted me to only redo the interest to show interest starting through the that treasury
I'm gonna cut you
calculation
off. I'm gonna
from
cut you off.
9.
I don't know what Judge Green did, but here's where we're at. You've got a judgment for $6,645. That's the number you start with. If you want a different number on your judgment, then we're gonna have to file a motion. We're gonna have to notify Mr. Wiley that you're after more money than that $6,645. It's
Okay.
probably not worth it, but that's an option. You have an option as plaintiff.
Right, and I'm not going to do that.
Okay. So do you have any more questions about what we've got going today and how you need to proceed to get that request in order?
Okay,
signed?
so I need to go back, do the recalculations, go back and have the form MC-19 filled out again and submit
Right,
it.
and I want you to show your interest calculations.
Okay. And then just to summarize again, number 1 was the original 6645 in there.
Judgment amount.
Okay, the judgment amount,
Right,
and then number 2,
right.
the total amount of judgment interest accrued is only
Post-judgment interest, correct.
is
And let's
only
see if we can get you a little help right now. Let's see if we can get you a little help. Any attorneys out there that know what the current post-judgment interest rate is? Not enough collection attorneys listening.
5.39, Your Honor.
5.39?
Correct, Your Honor, give or take.
Thank you, counsel. All right, ma'am. So that just saved you probably an hour worth of internet searching. So the interest rate since February 5th is 5.39%.
okay.
You follow?
Right, but Judge Oakley, what I'm trying to say is number 2 is only from the February date to current for
Correct.
that interest.
Correct.
Okay, got it. I got it. That's clear
Okay.
to me. Thank you.
Okay.
And then the total
then
amount.
the cost line is only what expenses you've incurred since February 5th, and you can break those down too.
Okay, well, since the February 5th, so I don't show VIX costs at 209.90 in there.
Yeah, but you told me the 209 was part of it was your filing fee for the original small claims action.
Correct.
You don't get that now. That's supposed to be part of your original judgment. It's post February 5th costs.
Okay.
All right. Any other questions?
Okay, and then the total amount of post/judgment payments made is 0 from the defendant.
Mr. Wiley. Right?
Okay, and then whatever the total cost. Okay, got
Whatever
it.
the math is.
Okay.
Any questions?
Nope, that's
Okay,
clear.
ma'am, I'm going to say this with the utmost respect. You're absolutely crazy if you're in the business you're in and you don't have an attorney.
Okay.
I've been very, very patient with you today. It's not going to happen next time.
Okay, I appreciate that.
You're welcome. I mean that sincerely. You're welcome. But you filed as a corporation, even though you don't need an attorney in small claims actions, you're not always going to get a court that's going to walk you through the process like this.
Okay.
You need to have an attorney that you can call and say, look, I got a $6,600 judgment against this guy in small claims. What's my next step and how do I do it so I can get it done the first time? You've spent hours with my staff trying to get this order in place, haven't you?
Yes.
As a small business owner, your time is more valuable than that.
Okay. I appreciate
At my
that.
advanced stage, I've just determined that just about all life's most important issues come down to a math problem. This is a math problem. You had an attorney that you dealt with on a regular basis. It probably wouldn't have cost you $200 to get all this right the first time. So when you filed it, the court officer was already out there looking for your money.
Okay. I appreciate it.
You're welcome. Good luck to you, ma'am.
Okay, thank you so much.
You're welcome. So on that one, just make a note that Oakley School plaintiff, she's going to refile. Heather, we got anything?
Nope, you're just Parkside versus Hillard is next, and then the four
Okay.
people in the waiting room are all on the same case at 10.
The ROA? Oh, yes. All right, I've got, let's look at Parkside again.
Your Honor.
Recalling Parkside versus Hillard appearances.
Yes, Your Honor. This is
Your Honor.
Carrie Weishaus on behalf of the plaintiff, P86739.
All right, Ms. Hillard, let's talk some dates again. Now that I've actually got the court's register of action in front of me.
Yes, Your Honor.
When was that date scheduled that your mom checked on?
May 10th,
Of
2022.
22. Thank you.
Correct.
Mm-hmm. What is that 10 o'clock? Go talk to her. What is it? What's the attorney's name? Go talk to her. She'll figure it out. Okay, counsel, response on behalf of plaintiff, please.
Yes, Your Honor. There are several issues, I believe, that are going on here. The original complaint and issue was addressed in 2016. However, the defendant claims that there was some type of identity theft. She has told me during our conference that she had filed a 2017 police report. However, it is unclear to me what would be on that police report as far as what would be brought to her attention as far as identity theft at that time. It has not been produced. We did send interrogatories to one of her several motions for different objections to garnishment and motions to set aside. Those interrogatories were sent out on May 3rd, 2022. Those were not returned. We have not had any response or any type of documentation showing her claims as far as identity theft or the police report that was filed in 2017 as she has claimed. The May 10th hearing, May 10th, 2022 hearing was rescheduled and notice was sent out the following day on May 11th. So the non-appearance is certainly not reasonable to believe that she had made reasonable efforts to see about that rescheduling, as well as the response as far as after that in a timely fashion. It's almost 2 years since that time of that hearing. And what seems to be happening is that she had had a garnishment in May of 2021, and there was a slew of litigation or filings after that time in response to her income tax garnishment, as well as there has been an income tax garnishment on her 2023 income tax return. And it seems to be a trend of having this. And the common theme seems to be, I wasn't aware of the hearing and there was identity theft. And it seems to be something that, certainly the time for discovery and the time to have addressed this and produced documents showing that there was identity theft has passed, as well as it not being a timely filing by any means, and not seeming that there is any true good cause here for this motion.
Thank you, counsel. Ms. Hillard, I'll give you a chance to respond if you choose.
Yes, Your Honor. In response, I just have to say, I've not, as far as a notice being sent out, if I wasn't in the country, I wouldn't have got that notice. I did the best that I could at the time, which was having my mom to check on things for me. I am a victim of identity theft. They've not requested anything from me, which I assume we would just go through court about. And again, even with serving, the address that they have on file, I have my license, and I just was speaking with the attorney about that. It shows a different signature. It shows a different address. It shows a different weight. It shows all of these different things that don't.
I could care less about the original lawsuit service. We're way past that.
Sure. Okay. So yeah. So like I said, I do have proof that I was a victim of identity theft. When I called the court last, I spoke to them. The hearing was May 10th. At the time, because I wasn't in the country, I relied on my mom to check on it for me and was told that there was no hearing that day. And so because my mail was being forwarded to her, I did assume that she would receive mail from me and that I would be updated. Since then, I couldn't do anything until I actually came back home, which I am here now. So to me, that's a reasonable amount of time, because as soon as I was able to, I did actually check on things. And that's my response.
Okay.
You know, like I said, I'm not a lawyer. I did the best that I could. Okay.
Your motion is denied. The fact that you choose to live out of the country is not the plaintiff's problem. You've had 3 defaults entered against you. This is the 3rd default that you now want to set aside. Yeah, there was a default judgment entered. Ma'am, I'm not going to argue. Your motion's been denied. I don't think there's good cause to set it aside, so I don't even have to get to your meritorious defense. Your motion is denied. The judgment will stand. Counsel, submit an order. Ma'am, you can appeal my decision. You just can't argue with it.
No, I don't want to. I just wanted to ask you a question. I'm not trying to argue or anything. You said 2 from what I saw in the court. I only filed 1 motion to set aside default previous to this one. So you're saying there's 3 defaults?
Okay, ma'am, I've denied your motion. The judgment will stand. Feel free to appeal me. The circuit court judges need work as well. Have a nice day.
Thank you, Your Honor.
Heather, what do you got?
I'm bringing them in now. It's the 10 o'clock case, Komodo, Shepherd, Jolly Lots, Hyundai. All the attorneys are here. Does everybody need a breakout room? Mr. Mueller? No. Mr. Betts? No.
No, I don't think so.
All right.
All right, people, what ruined my day? What are we trying to accomplish today on Zoom? What's scheduled?
Good morning, Your Honor. Richard Mueller, P58626, who was originally on behalf of ComData, but this is not my motion. I'm just here observing.
Good morning, Your Honor. John Betts for Plaintiff Court Officer Victor Lodich. My client filed a petition for a show cause order with regard to a vehicle that he seized pursuant to a court order that you issued. And you did issue an order to show cause against Hyundai Motor Finance for them to show cause this morning and why they have not cooperated with the officer, either in telling him what kind of balance was owed on this vehicle or coming forward with the money that is accrued for towing and storage of the vehicle. And Hyundai did file some kind of a response, but apparently it does not have a witness present this morning to contest what my client says.
All right, well, first, Mr. Betts, let me ask you this. How is Officer Loditz doing?
He's here with me this morning, Your Honor. He's doing much better.
Good.
He's available to speak with the court.
Okay, okay, all right. Good morning, Vic.
How are you doing, Judge?
Good. Are you on the mend?
Yeah, they let me out of hospital last Thursday, so I'm mending.
Good. Good, good. Glad to hear that. Glad to hear that. Thank you. Counsel for Hyundai.
Morning, Your Honor. Catherine Tomasic here on behalf of Hyundai Motor Finance.
I'm sorry, counsel. Hold on just a minute. The stuff on my phone here. Not yet. Yeah. Go ahead, counsel. I'm sorry.
Catherine Tomasic here on behalf of Hyundai Motor Finance, P66190. Your Honor, is it? Sure. Your Honor, we had filed an objection to the show cause order for numerous reasons. There's just no authority by the court to even hear this motion. Hyundai Motor Finance was never a party to this action. There's no subject matter jurisdiction to even grant the relief that they seek in this case. This show cause has asked this court to make declaratory judgments about facts and pleadings and claims that were never part of this case. They ask for damages that have never been established or part of this case. And they asked to divest Hyundai of its senior prior interest in this vehicle without Hyundai ever being joined to this case as a party. So it violates basic principles of subject matter jurisdiction and personal jurisdiction. This certainly cannot get this relief that they seek. There's never been any kind of action asking for this. So it's outside of the bounds of what this court can grant. And further, this has been debated ad nauseum with Mr. Betts. Hyundai has set forth its legal position as far as its purchase money security interest being senior. Hyundai has no obligation to pay a junior liener credit for the debt that they incurred as far as taking a car that was subject to a senior lien and having storage and towing fees. That's not Hyundai's obligation to pay. In fact, it's their obligation to pay Hyundai. And that is why Hyundai has filed its own circuit court action pending right now before Judge Heiss in Wayne County Circuit Court. Defendant Lotus, who's here, has been served with that. The responsive period is pending, and all of these issues, the declaratory relief that we're seeking, the damages that we're seeking, have been properly pled there and are properly before the court there. So we've filed a limited appearance here just to object to this show cause order and to ask for attorney's fees for having to do this, because Mr. Betts just won't observe the law that the black letter law that governs this matter, and he wants to violate my client's constitutional rights here by trying to divest them of an interest without personal subject matter jurisdiction. He refuses to observe basic long-standing law, and he misrepresents facts. Hyundai has provided him with the payoff. That was the supposed cornerstone of why he filed the show cause order in the first place, is that he couldn't obtain the amount of the lien that has been provided to him, and still he maintains this show cause. With all of those things being laid out in front of him, he willfully continues. So we've asked that this court would dismiss the show cause and give Hyundai attorney's fees for it.
Thank you. Let me make sure I got the facts right, Mr. Betts. So plaintiff has come data, if I'm saying that right. Defendant is Shepherd Transport. So Shepherd had a Hyundai in their possession that was financed by Hyundai Motors, right?
That's correct, but I think the judgment debtor is Abatha Jolly Jr. He's the fellow who owned this car, or does own this car.
Okay, so he was a named defendant on the other lines. Oh, he was defendant number 2. I got it. Right. Okay. All right. So defendant number 2, who plaintiff has a judgment against, had a Hyundai. Hyundai Motors had a lien against it, correct?
Yes.
That's correct.
Okay, all right. So Officer Lodich seizes the vehicle. All right, so explain to me again. I want you to respond now to counsel's arguments that I have no subject matter jurisdiction over Hyundai. So explain to me how I do.
Your Honor, I think you're asking Ms. Tomasek for her position.
No, I'm asking you to respond to her position.
Well, Court Officer Lodich seized an item of personal property pursuant to a specific court order that you issued. And there is no law anywhere that says he can't seize property that has a lien interest. And of course, after he seized it, he did whatever he could to figure out, number one, is there an existing lien? And even as of today, we still don't know exactly how they calculate the lien. We thought perhaps this car had been paid off. There's no indication that Hyundai has done anything to try to collect from its actual borrower. I see he's present this morning on this Zoom hearing. But what we're really looking for is some help from the court to try to resolve this situation. We think that Hyundai prematurely went to circuit court and filed a suit against my client, Officer Lodich. And everything that he did was based upon an order that you issued, and the action that he took was in compliance with the order that you issued. So I don't know how there could possibly be jurisdiction in another court to try to determine what was done pursuant to your order. So I'm looking for some help from the court to try to resolve this situation. As it stands, there's approximately $14,500 towing and storage bill on this car. The fellow who owns the tow yard has made an offer to try to buy the car, to pay some money and forgive the towing bill. Hyundai would not agree to that offer, did not make a counter offer. So we're kind of in a catch-22 here. It may be that this car is worth slightly more than the towing and storage bill of $14,500, but then I guess the next issue would be, let's say for sake of discussion, Officer Lodich auctions off this car, and let's say for sake of discussion, it brings $18,000. Well, how is that money to be distributed? Does it go first to the towing and storage, or does it go to Hyundai? So I just see legal issue after legal issue here, which we're trying to avoid.
Well, isn't it pretty settled law that as the finance company, they've got the primary claim against the vehicle and the value thereof?
I'm sorry, Your Honor.
I said, isn't it pretty settled law that as the underlying lien holder on the financing of the vehicle, they've got the first claim to any money generated from the sale of the vehicle?
I'm not sure at all that. I mean, all I know is that Officer Lodich seized this car pursuant to a specific court order. He has possession of it. He's always had possession of it. And as I indicate, to the extent maybe we've got some equitable issues here, Hyundai hasn't done anything to try to protect its interest, hasn't sued its customer, hasn't collected from its customer. These payments on this car have to be delinquent for well over a year. I mean, Hyundai can't just sit on its rights and then complain.
Ms. Kamask, response to that?
Yes, I do, Your Honor. You had asked Mr. Betts to advise you how he has subject matter jurisdiction, and subject matter jurisdiction is established by pleadings. There have never been any pleadings, that have ever filed to advise this court that anybody is seeking to divest Hyundai of its interest and take that senior lien interest away, which is exactly what they're asking for in the show cause order. They're asking this court to declare the interests of a party that was never served, and then assess damages and declare that Hyundai somehow, there is no legal device whatsoever that would obligate Hyundai to pay their storing and towing fees. That is exactly counterintuitive to the established law that Mr. Betts has been educated on by me several times, and he just ignores. And he can laugh, but I mean, I do have emails to back it up, and he's just declined to debate, but it's there, and he's been served. His client's been served with more black letter law in the form of the complaint that's pending properly before the circuit court. It is my client that gets to choose which jurisdiction is proper, not Mr. Betts. And it is my client that gets to determine how it gets to enforce its rights, not Mr. Betts. And the other matter that we have is because there's no pleadings that ask for this relief, there's no subject matter jurisdiction, is a hard stop right there. The second hard stop is there's no personal jurisdiction. If they were never served, it was only after this case was closed, and there's certain facts that occurred after that case was closed that they're trying to reopen the case on a party that was never joined and seek relief all over, like as if they could do that. I've cited in my objection multiple cases, case law on the basic jurisdictional requirements that makes an order binding. And being a non-party, this order that they got is non-binding on Hyundai. That's just how it is. It's non-binding on a non-party. We don't take any issue with the fact that Mr. Loddick seized the car. He was within his rights to seize the car, but somebody that seizes a car does so, assuming the risks of a junior liener. That's subject to a senior lien. And the damages that they might claim are self-inflicted, maybe out of regret for making a bad decision of taking a car that is already secured by a lien, which would have been easily determined if they just looked at the records. So it seems a little disingenuous to bring a show cause in the district court when there's a pending circuit court matter already addressing all of these issues. Hyundai is permitted to seize the car. That's the relief that they're seeking in the circuit court. They're entitled to do that. There's no basis to drag them into the show cause hearing here.
Go ahead, Mr. Betts.
Well, Your Honor, the real bottom line is you issued an order compelling Hyundai to show cause why it didn't do certain things. That order stands. Hyundai has not filed a motion to set that order aside. They haven't explained by way of a witness, by way of sworn testimony, what they did, why they did it. Nothing of that nature.
Your Honor, my client can't be obligated to do things that they're not compelled to do. They can't be compelled to do things they're not obligated to do, rather.
Let me cut you off, counsel. Today's the hearing on my show cause, right?
That's correct.
Okay.
Yes, and we filed an objection. Yeah, we filed an
to the bottom of.
Yeah, we filed an objection that we can't even have this hearing because of the lack of subject matter and personal jurisdiction. And we did ask to have that order set aside. That's part of our objection.
Right. Mr. Betts, anything else?
No, as I say, Hyundai did not file a motion to set aside the show cause order. All they did was file an objection. So, unless and until that order is set aside, it stands.
Okay, then I'll set it aside. I don't think I have any jurisdiction over Hyundai.
Thank you, Your Honor.
Your Honor.
Yeah, who's talking?
This is AJ Jolly, Abetha Jolly Jr. I'm the defendant in this case. I appreciate your time. The court officer also seized another vehicle from which I do not have a receipt, nor do I have.
I don't think that's in front of me today, is it, Mr. Jolly?
So I'm not sure how to go about this. I just want to make sure.
I can't give you legal advice, brother. I can't give you legal advice.
Okay, I understood.
I mean, it's not fair to parties if I let you argue a motion that nobody knew was going to be argued today.
I got you.
Or argue an issue.
Can I ask you about my firearm that he seized and I don't have?
I don't know anything about this stuff, Mr. Jolly.
Okay.
So
I'll file for it.
File something and serve whoever needs to be notified about it, and then we can have arguments.
Absolutely. I do apologize for my. Okay.
I'm not chastising. I'm just letting you know the way it works. It's not fair to bring things up that nobody knew was coming.
Understood. Thank you, sir.
All right. Okay. Anything else?
Yeah, Judge, I have to ask. We did ask for attorney's fees.
How much are you asking for?
We asked for $2,000.
All right. Mr. Betts?
Your Honor, Court Officer Lodich is the one that should be awarded attorney fees because, as is indicated in his petition, Hyundai has been completely unreasonable to deal with. This could have been resolved months and months and months ago if they had simply responded to his request for information about the car. They did not. The only way they ever come forward with the information, and we say, of course, the information is incomplete, insufficient, but it was after we filed the show cause, served it, went to all that time, effort, and money to do that.
Right. Let me ask you a question, Mr. Betts, and I'm not trying to trick bag anybody. So, court issues the order to seize. Court officer goes out and seizes the vehicle. It has an underlying lien on it. That can go to auction right now. Whatever it sells for, the lien's got to be paid off, right?
Well, that would be the issue. What comes first, the towing and storage, the officer's fees, or the lien to Hyundai? But I guess that specific issue is not before you this morning.
No, I'm just asking you. I'm just asking how it normally works, because I'm going back way back in the day when I used to do collections. And it was always the argument. The court officer had to figure out if the vehicle was worth storage fees, his fees, everything else before he ever seized the vehicle.
Well, the easy answer is ordinarily the money that's owed to the lender on the car is far less than the car's value. And of course, Officer Lodich thought that was the situation when he seized it way back when. He received information to that effect from the judgment debtor. And of course, if he got the cooperation from Hyundai, that would have been resolved way back when. Hyundai could have been paid off. The towing could have been paid off. There'd be some money left over for the judgment creditor. Everything would have been fine. But because Hyundai would not cooperate, refused to cooperate, and even today they take a belligerent attitude. We don't have to cooperate. You don't have authority over us. Go away. It's not that simple.
Which is all true. Unfortunately, it might not be playing nice, but I don't think that they've got any obligation to cooperate with a court officer that seizes the vehicle. If there's some legal obligation on behalf of the lien holder, tell me.
Well, this situation arises periodically. The real bottom line is, how does the court officer get this information? There's only one place to get it, and that's from the lender. And he tried his best, his level best. He sent letters, he made phone calls. They would not cooperate.
No, I understand what you're telling me, but what I'm asking you is tell me what authority there is that says they have to be nice and cooperate. I don't know of any.
I don't think we're going to find
authority.
We're not going to find a statute that says that anybody has to cooperate with a court officer, but I mean, that just general business in my opinion.
If they have no legal authority to cooperate, I'm not going to charge them attorney fees because they didn't.
Understood.
And I'm not going to award costs to Hyundai because if they would have been nice, maybe we wouldn't have gotten to this point. Good luck in circuit court. Somebody submit me an order.
Thank you, Judge. I will tell you that we did provide an affidavit that has those costs set out, and all they have to do is pay $16,000, $930.12, and they can get rid of Hyundai forever. Thank you, Judge.
All right.
Bye-bye.
Good luck.
Thank you.
Heather, what do you got?
We have live, no, Ian Morton, where are you? I'm sorry, Ian.
No problem.
Ian had a 9:45. Holiday versus Pelzer.
24-01768.
And Mr. Pelzer, we got a Mr. Pelzer or not?
No, Your Honor. Nope, no one appeared.
All right. Default judgment then?
Yes, Your Honor. At this time, we ask for default judgment for possession to be entered. Total balance is $3,702.29. We'll submit the proposed judgment to the court briefly.
Granted.
Thank you,
Heather,
Your Honor.
can I go backwards on, I'm sorry, Mr. Morton, was that done on that file?
All set. Yep. Thank you.
Thank you. Heather, can we go backwards to 9:15?
Sure.
TD Bank versus Medelsky.
Harms showed Palin didn't, and so Harms asked for an adjournment for May 21st.
And did you pick a time?
No, I
Asking
just,
for a friend.
yeah.
Okay. How about 10 o'clock, darts versus dart?
Well, at 9:45, Hercules Tire versus Madco and Hamilton.
Oh, yeah.
We have the attorney here for Hercules.
Okay. What's
that's it.
scheduled on that?
Albert Kim.
Counsel, your parents for Hercules?
For the record, Your Honor, Albert Kim, P70301, appearing on behalf of plaintiff in this matter.
Counsel, what's scheduled for today?
Your Honor, I believe the defendant probably got picked up on a bench warrant on this one. He had failed to appear for a creditor's examination. This is an old file.
Okay. And he did get picked up on a bench warrant?
That's my assumption, because this file, frankly, had been closed in my office for inactivity for quite some time.
Okay.
However, Mr. Hamilton seems to have been, we just had this date get popped up on our record, so.
All right, so let me, counsel, bear with me, and thank you for your patience today. This on base just doesn't work for me. Let me get a look at the ROA, because I'm assuming what happened is he probably got picked up on the bench warrant, and usually what we do is we give him another chance to say, look, here's your court date, show up for a creditor's exam. I want to make sure what happened. That's usually what happens. I want to make sure what happened before we go forward today, if you'll bear with me a little bit longer.
You're fine, Your Honor. Obviously, I'm doing it via Zoom.
Thank you, Mr. Kim.
Okay.
Heather, what about Dark v. Dark at 10? Michael Stillman's office?
Sorry, Judge, what?
Dark v. Dark?
Yes, Sean
Stillman's
Bowden is here
office?
on Dark.
Morning,
All
Your
right,
Honor.
Mr. Bowden, what's going on that one?
This is a pretrial hearing. Defendant has failed to appear.
All right, am I reading this right? Both the plaintiff and the defendant are named Dawn Dark?
No, the plaintiff name is Plaza Services.
Thank you. That was really confusing to me. All right, and you represent the plaintiff?
That is correct, Your Honor.
And no defendant?
No defendant.
All right. Pre-trial today, so I'm assuming you're after default.
Yes, Your Honor.
Thank you. You'll submit?
Yes, Your Honor.
Thank you, sir. Heather, how about
Thank you.
SMSC Federal Credit versus Gauze?
They are outside live. I gotta have Joe bring them in.
Thank you. All right, Mr. Kim on Hercules, let me give me a minute to look at the ROA here. Thanks for that prompt printing.
No problem, Your Honor.
Malachi. Yeah. Mr. Kim, I was correct. Shh, quiet, I'm still on the record. Mr. Kim, I was correct. It looks like Mr. Hamilton was in court on March 14th and given a date to appear for today. And judgment amount. Do you have the judgment amount? I'm trying to find it here.
Yeah, hold on, Your Honor. Let me pull it up.
Way back when it was $9,900, so it's probably higher than that now.
Yes, Your Honor, substantially. But Your Honor, again, we had had a settlement agreement at some point or another on this one. This is right when I started, nearly when I started with my firm. But I'd never heard from Mr. Hamilton again after that initial call, and I don't know if he had posted bond. I would just request that if he did, that be released to plaintiff.
I don't have any record that he did.
And then I would also move that his bench warrant be reinstated and see if he comes back.
Yeah, let's see if a $10,000 bench warrant gets him to take this seriously.
Understood. Your Honor, do we have to file it or does the court file those? I can't recall.
I don't like to do paperwork, so you file, I'll sign it.
All right, understood, Your Honor.
All right, counsel, once again, thank you for your patience.
Of course, Your Honor. Thank you.
Have a good one.
You too.
All right, counsel, your appearance, please, on behalf of SMSE, right?
Yes, Your Honor.
Your appearance.
Yes, for the record, Ron Scherf, P 23315, appearing on behalf of the plaintiff.
Thank you, sir. What do we got scheduled for today?
Your Honor, we appeared on January 25th for a debtor's exam. The defendant did not appear.
Okay.
At that particular time, I believe, I'm not sure if it was you or, let me see. I'm looking at my memo. Clerk said that we could submit a bench warrant at that time or a motion order to show cause. The notice to appear was done via alternate service. I never feel comfortable going to a bench warrant based on that.
I appreciate that.
So we did a order to show cause, and
today's the day.
You ordered the defendant to appear this morning for a show cause hearing.
No luck.
No luck. She was served.
What's your judgment amount, counsel?
I'm sorry, the judgment amount through today would be $16,951.65. I'll set it to your discretion on the bond amount. Setting a bond that high probably accomplishes nothing.
Yeah, but I will set one for 5,000. Let's see what happens.
Thank you, Aaron.
All right. You'll submit.
That's it.
You can submit that. I mean, if you want to go downstairs and handwrite it, I'll sign it today, or submit it electronically.
I actually have it.
You got
the
it
only
ready to
thing
go?
I'm looking at, Your Honor, is I see that as far as identification, we have race and we have date of birth. I don't have a driver's license number. You're going to want more identification on than that.
Yeah, I'd like to. I mean, it's.
I think we can get.
Yeah, let's see if you can get more.
Maybe a driver's license number we'll be able to get.
Okay. Yeah, so something more than just. Yeah.
Okay. All right, I'll do that, Your Honor.
All right, I just made a note. We'll make a note in our record, bench warrant to issue, and you'll get more info.
Thank you.
Thank you, counsel. Enjoy your day.
You too.
What are you ordering for, Hillary? Oh, okay. Yeah, you can have that back. Would you keep all that stuff together until May 21? Yeah. Actually, you know what? What day is May 21? Bring it up to me the week before. Yeah. And then you want all these? Yes, please. Thanks. Thank you very much for your help today. Yeah, small things. Yeah. Thanks, buddy.